to Emily Kyle. I personally have known Emily for many years, and she is a stellar speaker and a true expert on estate planning and planning for care, all tax and VA benefits, and many other things. Emily is a graduate of the Northeastern School of Law from Boston, Massachusetts. And she also has a degree from the University of Colorado, a master's degree in psychology from Boston College. She is a member of NALA, which is the National Academy of Elder Law Attorneys, and past president of the Arizona chapter. She's a member of the Academy of Special Needs Planners and the Special Needs Alliance. She is, of course, licensed to practice law in Arizona and has been licensed to practice law since 1993. The Supreme Court of Arizona reappointed Emily to serve on the fiduciary board through December 31st of this year. The fiduciary board oversees the approval and discipline of fiduciaries licensed in the state of Arizona by the Supreme Court. Her practice has been focused really on elder law and special needs planning and related issues, including, of course, all-tax, VA, and long-term care planning, which we're going to cover today, along with guardianship and conservatorship issues and estate and settlement and probate issues. So please join me in welcoming Emily Kyle. Thanks for joining us today, Emily.
Thank you so much, Lori, for having me. Thank you, Banner, for having me. And those of you who are participating, I appreciate you getting on this technology. Technology is new to me, that's for sure. And so I appreciate your efforts to join us for the program. I will tell you that I thought you were going to see a camera, so my office is as pristine as it has ever been so that you could see my neat and tidy office. So I miss seeing your smiling faces, but I'm so thrilled that you're here with us today, and we're going to talk about estate planning and then some ideas for paying for long-term care. And as Lori said, please use that chat box so we can get some questions answered. I'm here to be of assistance to you all and to better understand what your concerns and your questions are. So there are kind of these two ways that we look at public assistance: benefits that you're entitled to because of a medical condition or because you've paid into the system. And then we have other programs that are based on the fact that you have a need and perhaps your income and assets are low, even if you have a medical need. And so those are our needs-based benefit programs. So when we think of entitlement programs, we're thinking about Social Security disability payments and Medicare, both of which I'm sure you might be very familiar with. And when we're thinking about needs-based programs, we're thinking more about supplemental security income, or SSI, which would be for somebody who has not paid enough into the system and then becomes disabled, and so that they can get some payment from Social Security. And then we're also looking at Medicaid, which is the program we're going to talk about today, which in Arizona is called the Arizona Long-Term Care System, or ALTCS, ALTCS. And every state has their own Medicaid program. So we're going to go through some of the eligibility criteria here in Arizona, since that's one of the ways that we can help pay for long-term care. So I wanted to start with talking about estate planning, because the foundation to make sure that we can make appropriate decisions for those we love, and that people who love us can make decisions for us, is really through the estate planning process. And so while it might seem like a big stack of paper to many of you, it really is the opportunity to express who's going to make decisions and when they're going to make the decisions for you, and what the limits of that decision-making capability or authority might be. So these are sort of the general documents that we usually think about when we're doing some kind of estate planning. We're going to talk a bit more about the healthcare documents as well as the financial power of attorney, but I do want to just spend a minute or two talking about trusts and wills. And so when we think about trusts and wills, we're thinking about, for a trust, the management of assets that are titled to a trust now, when we become incapacitated, and then at death. And when we think about a will, or last will and testament, we're really just thinking about where does my stuff go when I pass away. If you have a trust, one of the most important things is to make sure that the trust document, that the assets you have are titled in the name of that trust. Assets that are not titled in a trust might have a beneficiary designation on them, or they might be owned jointly with somebody else. But the trust document really only controls the assets that actually have the trust name on them. So if I created a trust and I own my house, the title of that house or the deed that's been recorded would be in the name of the Kyle Family Trust rather than me individually. And that way, if I became incapacitated, whoever's next in line as trustee would be able to manage that real property that I have because it's a trust asset. If I had a house and it's just in my name and then I became incapacitated, then we're going to look to that financial or durable power of attorney that we're going to talk about in a little bit more detail later. So the fact that your attorney may have drafted a trust is great, but the next step would be to make sure that those accounts, those bank accounts, and pretty much anything other than your IRAs or 401ks or other pre-tax retirement money are titled in the name of the trust. If you have an asset and you have a joint owner on it, there's no probate and the survivor of that account would receive those monies. So if I had a life insurance policy with my niece, Marissa, as the primary beneficiary, and I have a trust that leaves everything to all 5 of my nieces and nephews, she's still going to get all of the life insurance and then 1/5 of whatever assets are titled in that trust. So you have to think of it kind of as it's really a standalone document and it's going to control the assets in that are titled in the name of that trust. And the will, on the other hand, is going to spring to life when you pass away. So it really has very little impact during your lifetime and is there just to determine where your assets are going to go when you die and who is going to be in charge of those assets.
So Emily, we actually have a question about that. And the question that came in here from Kathleen is, why are IRAs not included in the trust?
That's a fabulous question. Thank you for asking. So we can't retitle IRAs during our lifetime into a trust, or the IRS considers that we've made a distribution and you would have all of the income tax consequences. So IRAs and 401ks and 403bs and all of that variety of retirement assets are always just in the name of the wage earner. So even if I'm married, my husband's name would not be on that IRA account until maybe I die and he takes it as an inherited IRA. Having said that, you can have the trust be a beneficiary of the IRA. So you could say when I die, any money that's left in that IRA account would go to the trustee, and then the trust could say how the distributions of those monies are made to my beneficiaries, whether that's my children, my spouse, to charity, wherever those funds are going to go. And on that note, remember that nonprofits don't pay income tax. So if you have charitable intent, leaving an IRA to a charity means that they'll get 100 cents on the dollar, versus when you leave an IRA to an individual, when the distributions are made, they're going to pay income tax on that. So it might be a deduction of 20%, it might be a deduction of 35% or whatever the top rate is. So you want to be conscientious about how those beneficiaries are set up. Any other questions on that category, Lori?
Not so far. I think
Okay.
that makes sense. Actually, I will ask you a follow-up question. Are there other things aside from the IRAs and 401ks that you would recommend not be included in a trust?
So typically we don't have vehicles titled in a trust unless they're very expensive or antique vehicles that you think are going to stay in the family for a long period of time. There's no bar or prohibition from having vehicles titled in a trust. It just sometimes is administratively difficult to then sell or transfer them. So if I go to buy a car and the person who owns it shows me a deed and it's in the name of the Smith Family Trust, how do I know that the person signing the deed actually has the authority to sign for the Smith Family Trust? If it said Joe Smith on it and they show me ID that says I'm Joe Smith and it's my car, then signing the title over is easier. If you're going to go through a dealership or a broker, they would probably be more familiar with dealing with trusts that are vehicles that are owned by trusts. When we have people who have expensive vehicles, or as I said, antiques, or cars that have been in the family for a while and have memories for us, those maybe you want a title in the trust, because the likelihood that those are going to get distributed out to anybody other than a family member are very small. Other than that, I would say pretty much everything should be in the trust. That includes your checking and savings accounts. The whole goal is for somebody to be able to access those funds easily without a court proceeding in the event that you become incapacitated or pass away. I have had families that have added a local child as a joint owner on a small checking account in town, so they know that the person would be able to get access to the money immediately. I've also unfortunately had situations where that was set up that way and the child took the money and then the money was gone. It was impossible for us to get those funds back. So you just want to be conscientious about, if you're going to add somebody's name on an account, that you understand that they become a joint owner and may remove that even while you still have capacity.
Good point. Thank you.
So I tried to come up with kind of the general goals as to why it is that we really do estate planning. We want to have that flexibility to manage things when you're incapacitated. If you currently have a loved one who has dementia or some other cognitive impairment, you want to be able to access that retirement account, whether it's to pull out the required minimum distributions or to pay bills and make investment decisions. So the main goal, or one of the goals of that estate plan, is to ensure that you have that flexibility to manage somebody else's assets and that somebody would have the ability to do that for you. We might want the ability to transfer assets or use them in the event that you need long-term care. So we're going to talk about some techniques that can be used to kind of speed up the Altex process so that we can preserve assets for the benefit of a surviving spouse or the other spouse, the well spouse, and make sure that we can get whatever benefits are available to reduce that out-of-pocket cost so we don't end up with two people who don't have any money left. And then on the medical side, we of course want to make sure that we can make healthcare decisions, whether those are mental health or physical health decisions, without having to go to court and get permission to do so through the court system. And I put distribute your assets when you pass away as last, because I'm really mostly concerned about what happens to you when you're alive, and where your stuff goes when you die is obviously important to you and those beneficiaries. But really, we want to make sure we can take care of you and your loved ones while you're here with us. So let's talk a little bit about what a healthcare power of attorney is. Maybe this is straightforward to many of you, but it really is to appoint somebody to make your healthcare decisions. And I urge you to make a thoughtful decision about this and not just pick somebody and not just pick your oldest child. Make sure you're picking somebody who's going to be in it for the long haul, who's going to understand that these might be difficult decisions to make and is still willing to make those decisions on your behalf. And in your healthcare power of attorney, you can put information about whether you want to be buried or cremated, or even specific instructions about what to do with your ashes, or where you want to be buried, or whether you want to be with a former spouse or with a deceased child, or whatever those rules are. If you have religious beliefs, we can add that information to your healthcare power of attorney. What's important to you to happen at that time, or to direct people to a separate memorandum that would have that information. And you can also have information about whether or not you want to be an organ donor, and whether that's for transplantation only or you want that for research. I'm sure, as you know, Banner and other organizations, if somebody's been diagnosed with dementia, might have a lot of interest in receiving the brain or some tissue in order to do studies to help us figure out how we can eradicate or treat this in the future. And so that's another opportunity that with your healthcare power of attorney, you can achieve those goals. And I should say that your healthcare power of attorney typically is going to go into effect, of course, when the doctor says that you're no longer able to make healthcare decisions for yourself, although we have drafted them to be effective immediately, particularly if somebody has already been diagnosed with a cognitive disorder, so that we don't have to wait for the doctor to make that determination, and we can ensure that the person they've listed can communicate with the physician and help them make those choices. So living wills go by lots of names, including healthcare directives. And this is for end-of-life decisions. So this is, do I want to be on the ventilator? Do I want heroic measures? Do I want you to give me food and fluid other than orally? One of the issues that's come up for a lot of presentations and lately, and people are thinking about, is does my living will give enough flexibility in the event that I might need a ventilator for a short period of time because you've been diagnosed with coronavirus? Most of the time, the living will is going to give that flexibility because it really gives the authority to your healthcare agent to make those choices for you and not just say, oh, don't put them on a ventilator no matter what, unless that's what your wish is. A DNR, or a do not resuscitate order, is completely separate. That's a document that in Arizona needs to be on orange paper, and it needs to be signed by a medical professional because it's an extreme measure, of course. And in that document, you may have said, I don't want you to do anything. In the event that I have a stroke or a heart attack, I don't want you to try anything to resuscitate me. That document may need some changes because it may be that if you got coronavirus, you in fact would want to be on a ventilator on a temporary basis, versus if it says you're a DNR and you became unconscious because you were having trouble breathing, that you would not be placed on the ventilator. So it's important to review the documents. They don't all come from the same place. They're all unique, and you want to make sure that what you have is actually what meets your needs and your goals. And of course, those can change over time. With the coronavirus, life changed in a heartbeat. And so you want to make sure that you're reviewing those documents to make sure they're still meeting your goals and your needs.
And I often get asked the question where the DNR orange form should be. Do you recommend that someone keep it on their refrigerator or bring it with to the hospital? Like what kinds of recommendations would you have?
Yeah, so I would say, the paramedics are used to looking immediately at that refrigerator. So if you have a DNR, I think that's a great place to, if they've magnetized any more refrigerators, or tape it up there. It's also, in my opinion, incredibly important to make sure that your decision makers have copies of your healthcare power of attorney, your living will, and we're going to talk about the mental health power of attorney as well. It's pretty hard for a decision maker to be a decision maker if they don't have the documents and understand what your goals are. Also, we want to make sure that the health professionals know that they can talk to those folks. If it's your spouse, that might be very easy, but maybe it's not your spouse, and maybe it's one kid over a different kid, and you want to make sure that the right person not only has access to your medical information, but will have the authority to make decisions for you when the time comes. So providing those documents in your medical record to your physicians, to any hospitals that you may visit, they can scan that in and have that on record as long as you're a patient there. And then, of course, to get those updated forms in the event you change them, that those go out as well to your decision makers as well as the medical professionals that are involved in your life and in your care. So the mental health power of attorney is a document that's very unique to Arizona, and you might have a power of attorney, the healthcare power of attorney that includes mental health provisions. You would know that pretty quickly because it's a paragraph or a sentence that requires you to have initialed to say, yes, in fact, you want this authority to be with your agent. If you have no part of your healthcare power of attorney where there are any extra initials, I feel pretty confident in saying there are no mental health provisions in the document. So this is a document to allow somebody to admit you to an inpatient psychiatric hospital, sometimes called a level 1 behavioral health care setting. This is not your typical medical hospital. It's not an Alzheimer's unit. It's not a memory care center. It's not an assisted living center. This is literally a psychiatric hospitalization in a locked unit. For the most part, these are short-term stays, typically not more than 2, maybe 3 weeks, maybe shorter, depending on what's happening with the patient. And the goal is to avoid having to go to court and have a guardian appointed, especially when something might be a very serious emergency where that person needs treatment right away. Sometimes this is needed when somebody has a cognitive impairment and maybe their sleep cycle is completely disturbed and it's getting harder and harder to control that at home, even with medication, where they're up all night and sleeping all day. Also, folks who have cognitive impairments, sometimes their personality, the worst part of their personality becomes the most frequent part you see, or their personality changes and there are some behaviors that make it unsafe for them or for you. And so maybe it's just a medication change to reduce anxiety, but it's been difficult to manage that at home. Most of the time, the person will go through the medical hospital to ensure that it is not a medical issue, that it's actually a psychiatric condition. And in some circumstances, the facilities will send a team out to your house to do an evaluation if it's an acute situation to determine if the person is appropriate. So this is a very, very important document here in Arizona. Again, guardianships are public, they can be expensive and time consuming. And so we want to do what we can to avoid having to use the court system to make decisions that you should be able to make in the privacy of your own home and with your family.
And do you recommend, Emily, that people have a separate mental health power of attorney, or that it's a clause within their healthcare document?
I think either is fine. In our office, we typically put it all in one document, a healthcare and mental health care power of attorney. We've done them as separate documents, mostly when we have different decision makers. So we've had some clients where they know who they would want to make medical decisions, but they have a very different person to make those mental health decisions for them. And so in those instances, we've done two documents. What you want to make sure of is, like I said before, that you know where your documents are, your decision makers have copies and would be able to find the documents if necessary. So I don't think there's, other than that advantage, I don't think there's a difference in one or the other. It's just really important to have the documents so the decisions can be made. So now we're going to talk about the financial or durable power of attorney. This is one of the most important documents to have for a variety of reasons. The financial power of attorney can be called a whole bunch of different things, and so that's why I've called it the financial durable power of attorney. Sometimes it's called a general power of attorney, sometimes it's called a special power of attorney, sometimes it's a financial durable, sometimes it just says durable power of attorney. The name is kind of irrelevant. What we care about is, what does it say? What powers and authorities does it give? In some states, they have statutory powers of attorney, and it's a list, usually it's a list of all the powers, and then the person can either initial those individual powers or initial the box that says, I give you all of these authorities. So it might look like that, or it might be much more detailed as to what the authorities are. Sometimes the banks or other financial institutions have their own forms, and they won't accept anything else except for their own form. So even if you've done a financial power of attorney, on your own through the internet with an attorney, if there are accounts that are not titled in the trust and that are not held jointly, you probably want to make sure that you're still going to be able to access the account in the event that your loved one became incapacitated. And that might mean providing them with the power of attorney you have and just asking the question, hey, if so-and-so became incapacitated, can I still access account 1234? And the answer might be no. And so you would want to make sure you fill out the form at that institution to make sure that you can actually access the account. Unfortunately, we have lots of times where we end up still having to go to court because the bank is unwilling to comply with the power of attorney. Sometimes they say it's too old, although there's nothing in the statute that says it has to be less than 3 months old or 6 months old or whatever other made-up time frame they're providing. And quite honestly, why would we want to have a time frame on it? Somebody could have Alzheimer's for 10 years, and so certainly we can't continually have them re-sign every 6 months when they're no longer competent to do that. So make sure you're talking to your bankers or your financial investors, the life insurance company, the broker for the annuity, all of those kinds of assets to make sure you're going to be able to access that money or those assets when you need to. If you own property like your house jointly, but your spouse is incapacitated in some way and the house is not titled in the trust but is titled jointly, this power of attorney is the document that will hopefully allow you to sell the house. Typically, you can't transfer it to yourself unless there's specific authority in the document for you to act in that self-serving way. So sometimes a form off the internet works great, and sometimes it doesn't give you as much flexibility as you might need later. As we talked about, the IRA and other retirement accounts are always in the name of the wage earner. And so that would be another kind of account that would be difficult for you to access in the event that the person who owns it is now incapacitated, because it won't be in the trust. And so making sure that that power of attorney is going to work will be very, very important. Also, for Altex purposes, if your income exceeds a certain cap, you might need something called a Miller Trust or an income-only trust, and you're not going to be able to sign that trust document unless your power of attorney is going to give you the authority. If we don't have a power of attorney, you're not on jointly or as a signer, and it's not in the trust, we might end up having to go to court in order to give you authority over those funds. And while attorneys make a lot of money on court actions, we don't want you to spend money where you don't have to spend it. So make sure your documents are going to work and that they're up to date and they have the right people in there to make the right decisions. So we're going to turn now to talking about how you actually pay for long-term care, because as you know, it's not free. And so these are sort of the options that exist in order to pay for the long-term care. And when I'm talking about long-term care, I'm talking about whether that's somebody to come into the home and provide services because somebody's not safe anymore alone, memory care centers, assisted living homes, group homes, nursing homes, ventilator care, day programs, kind of a whole gamut of services that can be provided to somebody who is in need of those long-term care services. They're expensive, very expensive. And so we want to figure out the best way to use your money to take care of the person that you love without bankrupting yourself and then not having enough to take care of yourself. I'm sure for those of you who attend support groups, you're told very frequently, you've got to take care of you in order to take care of somebody else. And the same is true here. We need your financial house to be in order for yourself and for the person that you're trying to take care of, or the whole house falls apart. So of course you can pay privately. I would say the average cost of care in an assisted living center is probably in the $5,000-ish range, $5,000 to $6,000 a month. There's certainly some group homes where those costs might be much less than that. You know, we've had a couple of clients in group homes in the $3,000 to $3,500 range, but I would say the average cost is in the $5,000s a month. If you have long-term care insurance, now is the perfect time, if you haven't done it already, to investigate what benefits are available through that long-term care policy. Sometimes those long-term care policies only cover nursing home care. Sometimes it has to be at a facility where there's an RN available 24/7. And other times they'll actually pay for a family member to provide the services, whether that's at home or somebody in a group home or assisted living center. So you want to understand what the terms are. Some of those long-term care policies also, there's a waiting period where you have to pay for the first 30, 60, 90 days on your own before the policy kicks in. So it's really important to understand what it's going to do for you and what it isn't, how much it's going to pay, what the total amount is that's going to be available under the policy for the lifetime. If you each have your own policy, sometimes we've seen policies where there's a maximum in the policy total, but if you've used it all up, there's nothing left for the other person. So really important to understand what those benefits look like. Medicare will cover some services, but Medicare does not cover custodial care. They're not going to make that monthly payment to the assisted living center or group home. They might provide some in-home care on a limited basis, particularly for therapies. And they're going to provide some services in a nursing home after a eligible hospital stay, again, for those rehabilitation services. So don't think that Medicare is going to pay for the long-term care costs. And then, of course, we have Altex, which is where we started this whole conversation about a benefit that's based on need. So we're going to talk in detail about that in just a moment on the next slide. And then we have some veterans benefits. It's always hard for me when I do veterans benefits because the pool of people is small, and so it's hard to listen through for information that might never apply to you, but you never know who you might know or meet who might have a need, and having just a little bit of information so you could pass it along and say, hey, I don't know very much about this, but this might be a program that would be really helpful to your loved one. So I hope you'll stay through all of the presentation and learn a little bit about VA benefits. So Altex is Arizona's Medicaid program, and Medicaid in Arizona is AHCCCS, the Arizona Healthcare Cost Containment System, which the acronym is in the third bullet there. But Altex is the long-term care piece. That's the one that helps to offset the care costs at a group home or an assisted living center or a nursing home. It is a cost-sharing program, so there is some amount that the applicant will need to pay, most likely, unless they're married and their spouse has very low income. And it's really important to know that every state has a different Medicaid program. So what your friend or your relative has in Pennsylvania or Iowa or California or Michigan is going to be very different than what we have here in the state of Arizona. And the programs change over time. So maybe 15 years ago, you had a relative who needed to go on Altex benefits. The program probably looks very different now than it did then. So understanding the current rules will be important for you. It really is the net, the safety net, to make sure that folks who can't afford to pay for the long-term care costs don't end up homeless, that we can make sure we have a place where they can go and that they can be cared for. And Altex is never going to pay for care at home 24 hours a day, 7 days a week. It's called the Arizona Healthcare Cost Containment System. So they really are looking for the lowest cost alternative to meet the person's needs. That doesn't mean that you can't get 24-hour care. It might mean that Altex is going to provide the first 6 hours a day, 5 days a week. And if you have the funds, you can pay for the rest of the care at home. But the Altex program is not going to pay for that 24/7 care at home.
Emily, can I ask a question? We have Diane here who says that she was advised to do a special needs component of the documents in their estate. And she wondered, how will this help when she's applying for Altex for her spouse?
So I hope I'm understanding the question correctly, so I'm going to answer it in two ways. If you have a will, and in your will it says, hey, if I pass away, but my spouse is still living, and my spouse is receiving Altex benefits, the share for my spouse that they would get for me is going to go into this special needs trust or provisions for a special needs trust so that they can keep their Altex benefits, and there'll be an extra pool of money basically for that person. And so that's kind of a technique to use that would only come into effect after you've passed away. Most of the time when we have spouses, if they have children in common or they've agreed to the beneficiaries, by the time we submit the application, the assets are all in the name of the well spouse, the one who doesn't need Altex, and the accounts are set up to be payable on death to different beneficiaries so that that person not only won't lose their benefits, but that we can use the money in a discretionary manner to take care of the person, which the Special Needs Trust will also accomplish. So that's the reason to put it in your will, and it can only be in your will if it's for a spouse. You can't have a Special Needs Trust in your trust document for a spouse and have it work for Medicaid purposes. There are also other kinds of Special Needs Trusts for folks who are, so if we have Medicaid for a disabled person who's under age 65 and I want to leave them money, so let's say my niece who has Down syndrome, I can set up a Special Needs Trust during my lifetime and say, hey, any share that would go to Marissa goes to this Special Needs Trust so that she can keep all of her benefits. So there are other restrictions related to doing special needs planning, but the most common I see between spouses when one spouse has a cognitive impairment is to put those provisions directly in your will so that there's a trust for them when you pass away without them losing their Altex benefits. So I hope that that was the question that was being asked.
Yes, thank you.
So Altex covers a whole lot of stuff. As I said at the beginning, when I think about long-term care, we aren't just thinking about nursing homes. We're thinking about a whole variety of services that can be provided through Altex. So if you're applying for Altex, you would want to make sure that the caseworker that's assigned to the matter can help make sure that you're getting everything that you would be entitled to, whatever that might be, including therapies or that adult day programs if you want your person to stay at home. Typically, if somebody's on Altex, they're also going to pick up the prescription drug and co-payments that may otherwise need to be paid under Medicare or private insurance. So make sure you're getting the most that you can get from the Altex program in the event that your person becomes eligible for those services. Unfortunately, Altex doesn't cover everything. It is a welfare program. So part of the reason we want to do planning when we can is to cover the things that are not covered by Altex, like hearing aids and glasses, most dental services, and Altex pays on a shared room rate. So if you want your loved one in a private room, you're going to have to come up with some additional payments to that facility in order to cover that extra, the private room, that extra charge. So be conscientious about that. We have some basic criteria in order to become eligible. You have to be here under a condition that makes you legally in the country. And when I say an Arizona resident, that only means that the person has an intent to remain in Arizona. So it doesn't mean that they got a driver's license or they're voting in Arizona. You just have to have an intent to remain. So you get off the airplane whenever people fly again, and you say, this is where my mother is going to stay, or this is where my husband is going to stay. That's an intent to remain in Arizona, and that's sufficient. We do have, however, have a medical, an income, and an asset test in order to meet the criteria. So these are the things that are really the basic crux of the eligibility determination to make sure somebody is actually going to be eligible to get benefits.
So if somebody has a parent that is living in Iowa, but they've developed dementia and now the adult children are relocating them to Arizona, as long as that person intends to stay here, they are considered an Arizona resident and could qualify if they meet the other criteria?
Yes, if they've traveled to Arizona and now they're going to stay in Arizona, they should be able to get Altex benefits, assuming they meet all the criteria, even if they were living in a different state. We have had situations where the parents have come to visit and the child realizes that mom and dad really have a cognitive impairment that's much worse than they had anticipated, and they don't leave Arizona. And now we have folks who are on Arizona Altex. Even if you ask that parent, they would say, well, I live in Iowa. Well, you live here now, and this is where the person's going to stay, and that would be enough for the intent to remain in Arizona and apply for benefits. So let's talk a little bit about what the medical criteria are. They're really looking at the normal activities of daily living as the base, but then it really is more than that, because they're also going to determine, what can you do by yourself and not by yourself? How oriented are you to time and place? Do you know who the president is? A whole bunch of questions that are going to be asked of that person. In some ways, the assessment on the medical side is very, very similar to the assessment that would be done if you were applying for your long-term care policy. So if you have any familiarity with that, often the criteria are very close. Altex does their own assessments, so having the medical information available so that we can help make the determination and help Altex make that determination is very, very important. But they're going to come out and do an assessment, which right now they're doing by phone instead of in person, of course. But you'd want to have the last 6 months probably of medical records so that you could present to them what has been going on with the person. They have to be basically at risk for what they call institutionalization, which is meaning that they could not live alone, that they need to be in a facility in order to remain safe, even if they're not currently in a nursing home and there's no intent for them to go to a nursing home. So this is the tool, this is what they call it, the PASS, that Altex workers use to determine eligibility. When somebody has dementia or some other memory impairment, it's very important to see if you can get a letter from a neurologist that says that what that diagnosis is for the person. It's the only diagnosis where you get extra points. And so you need a certain number of points in order to be eligible medically. And you get about a third of the points from that diagnosis of dementia or Alzheimer's or Lewy body or frontal temporal dementia, whatever it might be for your person. It's important to have that on the letterhead of a neurologist or from a place that sees those kinds of patients, because as I said, you get about a third of the points. And so it's the only time it's a positive, I think, to say I have Alzheimer's, because you get a bunch of points for it that gets you closer to the medical eligibility criteria. If the person's denied medically, you have a right to appeal. You would want to make sure, again, that you have new medical documentation to show what's wrong. Things like being a fall risk are also, we would want that in the medical record, because that's also helpful to show why the person is not safe to live independently and by themselves to get through the medical process.
So is it a letter from your primary provider, primary care provider then, saying that the person has Alzheimer's disease is not enough? Altex really wants a specialist?
Typically they do. They want a specialist. The information we've received is they're really looking for the neurologist to have made the diagnosis and have seen the patient. Even if the patient is seen by lots of other doctors afterwards, to have at least one letter from the neurologist is very important. In the past, the letter from the primary care doctor was enough, from the nurse practitioner was sufficient, but we really have seen them tighten that up and ask for a letter from a neurologist on this kind of a diagnosis. So we encourage people to see whether they can get that, particularly when we have somebody who the question of whether they're going to pass might be a little bit more suspect. You know, we have lots of people who are really not safe to be at home, but a 5-minute conversation, maybe you're not going to know what their limitations are. So I would say the healthier the person is, the more functional they are, the more important it is to get the letter from the neurologist. So one of the other criteria relates to income, which I talked about a little bit at the beginning when I was talking about the Miller Trust or the income-only trust. And so if the income of the applicant is below $2,349 of gross income a month, that's before your Medicare deduction, before any taxes get taken out, or if you're married, if the applicant's income is more than $2,349, but their combined income is less than $4,698 or twice $2,349, if my math is right, then we're fine. But if the income is above that, even by 1 penny, we're going to need that income-only trust or Miller Trust. People get super confused about what that means, and so that's why I call it an income-only trust, because it's not about anything except for income. You can't put assets in it. The manual is very clear that it is not meant for resources or assets. You can't move a bank account in it and say, okay, I opened this new trust account and now I'm below the asset test. That's not the way it works. The goal is to say, I have too much income, I now have this new special kind of trust and a new account that I've developed, and I'm going to follow the Altex rules about what I do with this money, and now magically I am below the income cap and everything is fine. So there are a bunch of forms to fill out, there are a bunch of rules about how you can and can't use the money, but the goal is that this is required if the income is too high. If your income's too high and you don't do an income-only trust, you cannot qualify. If your income is below the income cap, there would never be any reason to create the income-only trust. So be conscientious, don't listen to the rumor mill. because it is not used as a spend down. I'm putting in air quotes. It's totally just because the income is too high.
And Emily, sorry to interrupt, but with the Miller's Trust, so where does that money end up going? So say the person with dementia develops, their care partner creates a Miller's Trust to funnel that income. Where does that income go once they pass? Does Altex seize it, or does the family hold on to it? How does that work?
Yeah, so the income goes in each month, and then we have things that it would pay for, including supplemental insurance for the person who's going on Altex. A portion of it most likely is going to go to the care home where the person is residing. If they have a spouse, money might be going to the spouse. The goal each month is for all of the money to be spent out of that trust so that it's a zero balance at the end of the month. But that doesn't always happen. Any money left in the trust at the death of the applicant becomes the property of Altex until they tell us it isn't. And because the amount would be small and the lien they have against that bank account is up to the amount that was paid for care, most likely the state of Arizona is going to get those funds back. My opinion is that's fine because they were paying while the person was alive, which allowed the family or the spouse to hold on to more money. But the goal is for that account to end up with a zero balance each month. Therefore, there would be nothing to collect. But if there is anything left over, that's what would happen to it.
Okay, and then can I ask one other question? We had a question that came in about the report that you said that we should get from the neurologist saying that the person, has Alzheimer's or a related dementia. And I heard you say that, a primary provider is not a good substitute for that Altex has really cracked down. But they're asking about what about another dementia specialist, like a nurse practitioner or a psychiatrist who specializes in dementia? Would that fly, do you think?
I would do the best you can. So whoever is the provider that's providing the services, I would get that letter. But I am stressing to you that the direction that Altex has gone, for reasons that I cannot explain to you, really is that it should come from a neurologist. I would say that unfortunately the nurse practitioner is probably the one with the least sway for Altex. They're going to be looking for somebody who is a doctor. So that would be my last choice. But I think you should do what you can, and maybe that person needs to put some more information in that they are a specialist in this area, that this is what they focus their practice on, a little bit more information in there. And again, if the person is higher functioning, I think that's much more important. I think if the Altex worker goes out and it's clearly obvious about what the limitations this person has, then that diagnosis from the neurologist might become less important. But I would do what I could to get it from the neurologist when you can and have it in your file for later. If they don't have to be seen by that person on a regular basis, but at least to get the diagnosis.
Yeah, and I think you're right, because I know actually at Banner Alzheimer's Institute, some of our dementia specialists are geriatric psychiatrists, and we haven't seemed to have a problem with that. Hopefully it doesn't become one, but I think your advice is really sound.
So the next criteria relates to financial eligibility, and so the applicant cannot have more than $2,000. So I talked about the income limit of $2349. That's money that comes in every month from Social Security and pensions. The assets are what's left in the bank account at the end of the month. So that applicant cannot have more than $2,000. It is a really, really, really small amount of money. It is a number that has not changed since the program was put together, 25 years ago. It has never changed. It's $2,000. So it's unfortunate, but that's what we have to work with, which is why people do planning to try and preserve as much of the assets as possible and still get some benefit of the program, because it's pretty frightening to think about spending everything down to $2,000 and then hoping that the state is going to say it's okay for them to start paying for care, and then there's no money for those other things like hearing aids and eyeglasses and a private room and the things that we were talking about earlier. Now, if you're married, the spouse can keep up to 1/2 of the total countable resources, up to a maximum of $128,640. But again, they're looking at half of the assets up to that maximum. So it's not an automatic up to the 128. By the same token, we have a floor. So if you only have $30,000, the well spouse is going to be able to keep $25,000. The ill spouse is going to get to keep 2,000, and the rest of the money is probably going to be spent pretty quickly. So if she has 30,000, she gets to keep not just 15, which would have been half of whatever those countable resources might have been. So we have countable and exempt assets. And so the applicant or spouse can keep a house as long as it's in Arizona, because it's hard to show that they have an intent to stay when they don't, or they're going to return to their house when they don't have one that's here. One car is excluded. All of your personal property is excluded. So nobody's going to go in and inventory your home and count how many chairs and what clothing you have. And most burial or cremation is also excluded so long as it's either below $1,500 or it's an irrevocable plan, meaning that it does not have any cash value. We can't cash it in and get money for it. I had said that it's a cost sharing arrangement. So typically some of the applicant's income is going to go to the facility, maybe less if they're getting in-home care, and then Altex is going to pay the difference. So if you're at home and the person's income is not more than $23.49, they're probably not going to have to pay for any of that in-home care because the state recognizes that they still have to pay rent or a mortgage and a utility bill and for food and other expenses, versus if they're in a facility, the facility is providing all of those services. And so in that instance, the person on Altex typically can only keep about $115 a month of their income, other than an amount that may go to the spouse for spousal support.
And so, Emily, if somebody qualifies for Altex and they live in Arizona and they have a house, but they move into assisted living, can they hold on to that house, or does Altex say now you have to sell the house because you're not living there? Are there any stipulations with that scenario?
So if it's a married couple, that house is still an excluded resource, even if one spouse is living in a community. If it's a single person and they no longer live in the facility, but they're not in a nursing home, then as long as they have an intent to return home, which is basically a statement that says, yeah, I'd like to go back home again, the house should still remain to be an excluded resource, but there is some estate recovery options at the end of that person's life. If there's a beneficiary deed on the house, most likely there won't be any problem in keeping the house, and the house will go to the heirs when that person dies, as long as they have not been in a nursing home for 90 or more days, in which case the state can put a lien against the house. There are a bunch of exceptions, as there are to every rule. So if you have a child who's lived with you for more than 2 years, the house is probably safe. If you have a disabled child, the house is probably safe. If you have a sibling who has an equity interest in the house is probably safe. And if you're married, the house is safe. That they will not take your house, they will not put a lien on the house, they will not collect your house when your spouse dies. Your house is very safe as long as you are a married couple and your name is on that deed.
Okay, and then we had one more question from Diane. She says, so if she has a $250,000 IRA, and that's all she has, no other savings or investments, half of the IRA needs to go towards her spouse's Altex expenses?
So we're going to talk, we're going to talk a little bit about the spend down. The answer would be if that $250,000, and I should say, I'm not giving legal advice to anybody who's joining us today. For purposes of today's program, it's just informational. And you should, of course, always seek the advice of the type of person, the professional that you think you need help from. But in general, if I'm married and my spouse needs care and it's his IRA of $250,000, I would get to keep $125,000, and then I have to figure out what to do with the other $125,000. But it can't stay in his name because he can't have more than $2,000 to qualify. So that's what people are talking about when they talk about a spend down. My preference is to call it planning, because I don't want you to just spend your money frivolously. It's really hard to get, and it's really easy to get rid of. So we want to make conscientious decisions about what to do with the money. So there are some planning opportunities. It matters whether you're single or married. And this CSRD is the Community Spouse Resource Deduction. So that's looking, Alltech's looking and saying, okay, when the person first needed care, they had $250,000. Now they're applying. We know the spouse gets to keep 125 no matter what else has happened, because when they first started needing care, that first 30 days, those were the total resources, and that won't change over time. We have some clients who end up getting divorced, although that's very, very rare. We've had it a couple of times when the well spouse was about to receive a large inheritance. It was our way of not having to also figure out a plan for the new money that was coming in. But it's pretty rare that we're looking at divorce for the option, but we certainly have. So these are some of the ideas that we've come up with for what we can do. So in the instance that Diane was talking about, it's possible that the other 125 could go into the single premium immediate annuity. And so that money, first it's retirement money, so you're going to end up with some tax consequences. But once the tax has been paid, assuming you didn't need cash to prepay a facility for a few months, the money could go into that annuity for the spouse, and they're going to get the money out over time. And so that no longer counts as a resource, assuming that that annuity was set up in a way that meets all of the requirements for Alltech's. I know this is a lot of detail, and I know that it's really dense, and I'm not asking for you to understand every single detail. I just want you to know that there are planning opportunities for whether you're married or you're single to try to preserve some of the money so that all of it isn't spent immediately on care. So I hope that you'll just bear with me and take a deep breath and trust that there are some options that can be done to preserve the money. And for a married couple, the single premium immediate annuity is a really, really great option. I don't sell any financial products. I don't make any money off of them at all. But this is a way that we can shift money and make it no longer countable for Alltech's, even though we've gone ahead and disclosed it, of course, to the Alltech's office as to how we bought it, where we bought it from, who the beneficiaries are. So the spouse can be their beneficiary at the time that the annuity is purchased, understanding that if the well spouse dies first, the money will go back to the ill spouse, which will probably make them ineligible. But to me, that's not a problem, because the goal of planning is to take care of the living people. And so we will have accomplished that. So it's possible that Diane could end up with all of the money that she started with, other than the taxes that were paid when that IRA had to be cashed out.
And that explanation you gave to Diane about the IRA, does it matter whether it's in her name or her spouse's name? Because she's saying it is in her name.
So if it's in her name, again, she would get to keep 125. That could stay in the IRA, so she didn't have to pay tax on that. And then the other half is still going to have to be cashed out, because she can't have 250,000 outside of, well, I shouldn't say it has to be cashed out. It could go into a single premium immediate annuity that is also a qualified benefit. And so she would just pay tax as the distributions are made out of that annuity. It's also a little complicated, because if she doesn't have access to the money yet, because maybe it's not fully vested, or it's at a company and she can only get it at a certain time, it can't be counted until she can get it. But if it's in an IRA that she could walk into and cash the whole thing out, then it would be considered a counted resource. And as I said, she could keep 125, put the rest in a qualified single premium immediate annuity, and therefore spread the tax hit out over a longer period of time. I talked a little bit about beneficiary deeds as a way to avoid any estate recovery on real estate in Arizona. Transfers between spouses don't have any impact on eligibility, so people are usually concerned about ending up in what they call a transfer penalty because money was given away. And so we don't have that issue so long as the money went between two spouses. And we're going to talk about other transfers, but there's no penalty for transfers between spouses. You can, of course, always make purchases for the applicant or the spouse. If you need a new washing machine, you can buy a new washing machine. If you need a new air conditioner, you can get a new air conditioner. If you need more clothing, you can buy more clothing. You just can't buy things for other people. Burial arrangements, again, so long as the total is under $1,500 or it's irrevocable, are also excluded. And so we always recommend that people do pre-planning on that front when they can, so that we know that it's taken care of. And since the money has to be spent, let's spend it in a way that's useful. Making gifts to family members can be complicated, and so we need to make sure that if that's happening, that everybody understands the complication that comes along with having made that kind of transfer, because that's a gift that's giving away something for less than fair market value, and that can definitely have an impact on when the person will be eligible. So every rule pretty much in Altex has some kind of exception, and the Altex manual is super helpful. It has lots of examples in it, but you need to be really careful about what you're going to do if you don't have guidance. So whether you've paid for a child's education or medical expenses, or you've given money to the church, the synagogue, the mosque, the Arizona Humane Society, the charity, whatever you've done with it, if the money did not benefit you or your spouse in the same way that the cost was, then you have made a transfer, which if made within 5 years before you apply for benefits, will impact when your loved one will be eligible. So it's completely the amount of money that was given away is what determines how long you have to wait. So if you give away $100, there's really not going to be any impact on eligibility. If you've given away $15,000, even though that's okay under the tax rules, it's not okay under Altex, meaning that that will result in about a 2-month penalty or waiting period before your loved one is going to be eligible for benefits. So if they're down to 2,000, you've got your 128, you've set up your SPIA, you've purchased your burial or cremation plan, and you apply, and it's May 1st, and you had either one, you or your spouse, gave $15,000 to your child, that means there's no eligibility for May, no eligibility for June, and sometime in July, Altex will start helping with care. Now that might be perfectly fine because maybe it's not going to cost $15,000 for care within that time frame. I don't know the answer to that. So doing gifting, we have to figure out the math question of, well, they get this much in Social Security and this much in pension, so they're really only spending $2,000 a month of their own money. So we've set aside $15,000 for that 2-month time frame. We've only spent actually $4,000 of principal out of your money. So we do gifting as a technique. We have to think it through. We have to figure out what the consequences are, but it can be a very useful tool to save some money for all of those extras that we talked about, particularly when we have not a married couple and we don't really have the option of that single premium immediate annuity to use to just have money over to the spouse, because as I said, there were no transfer penalties for the spouse. So again, I don't want to get lost in the weeds. I just want you to understand that there are some techniques that can be used if used appropriately to try to preserve some of those resources, so we again are able to have as much money as we can to take care of you, to take care of your loved one, and also to take care of maybe other people that need the care. There are also exceptions, as I said, when you have a disabled child or you have a minor child. We might be able to move money to those people without there being any impact on eligibility. So we would want to know what all those details are to make sure that we're making the correct decision. And
so if the applicant is, their car's kind of on its last leg, or their house is pretty cramped, or they want to take their kind of the last hurrah vacation when we're able to travel again, would those things count against Altex application financially?
So excellent question. So if you need a new vehicle, you should buy a new vehicle. There's no impact on eligibility to get a different car. If you're going to go on vacation, that's fine. But if you're going to pay for your kids to come with you, that's going to be a problem because you can only use the money for you or your spouse. You can take art classes. You can learn to play the banjo. Oddly, you can go buy a very expensive purse or expensive clothing, and as long as it's for you, there's no impact on eligibility. But if you give money away to somebody who's not you or your spouse, regardless of your good intentions, whether it was to pay for somebody's education or medical expenses or the wedding, all of that are considered to be transfers and will have an impact on when the person will become eligible to get some help from Altex. Because again, the idea is that if, let's say I'm a single person and I have $1,000 a month of Social Security, and so I need to go to a place that costs $5,000 a month if I were just to walk in, and I have dementia and I have no other assets. If I'm eligible for Altex, I'm going to pay $900 to that facility. I'm going to keep my $100 a month that I get, and the state of Arizona is going to pay the difference. So I know that I always have a place to stay. So the benefit can be extremely important because it's offsetting that long-term care cost. If I'm married and I have $1,000 a month and that's my only income, again, I'm going to pay some small amount to the community now because the rest of my income is going to go to my spouse to take care of him. And again, the state is going to pay for care. So now my spouse isn't spending $5,000 a month for me. They're spending my income maybe or some portion of my income, but not all of the income and all of the resources in order to meet that need. So the benefit of Altex is to offset and decrease that monthly cost of the long-term care facility or the caregivers coming in to provide assistance. Sometimes I get lost in the rules and I forget that people don't know what Altex will do. So all those covered services that we talked about at the beginning of the program, all of those are things that Altex will either pay for or help to pay for. If somebody's on Altex, again, Altex is going to pick up the cost of coinsurance and deductibles, including for your prescription drugs. So all of that can be a huge savings on top of that monthly care bill that comes in. If you add somebody's name to a bank account, Altex still considers it your money. So that's not a problem if you do that for convenience, and as long as the person you've added on doesn't steal money from you, that's totally okay. But if you add somebody's name to the deed who didn't participate in the purchase and is not your spouse, you've made a transfer of some part of the value of the home. So again, you just want to be really conscientious about what you're doing to determine whether or not it might have an impact later on when you actually need the Altex benefits. And when I talk about transfers, as I said, Altex says, did you give away anything within the last 60 months? That is 5 years prior to the time that you made the application. And it doesn't matter whether you did it the minute beforehand or you did it in the 59th month. Whatever those gifts are, all get added together to determine what the waiting period is before you can get some help from the state of Arizona to cover care costs. So some other things to think about. Altex is a managed care provider, so you have to make sure that you pick a provider or a care facility that is going to be covered by Altex. You can also have a provider, I'm not telling you you have to switch your physicians. Whatever your health insurance is will stay the same. Your Medicare program is going to stay in effect. Your supplemental health care is going to stay in effect. But if you're going to get services from a home care agency or need to go to an assisted living or group home, then you have to make sure that it's a place that actually has a contract with the state to provide services. Some of the facilities will require that you privately pay for some period of time. So you would want to know that at the beginning so you have enough money to pay for that time period. How long that will be totally depends on the facility. It's not an Altex rule, so there's no way for me to tell you what that time period is. Might be 6 months, might be 3 years. Also depends on what their census looks like. Do they have any open rooms? How many Altex residents are they willing to have in their facility at one time? And Altex pays on a shared room rate. So if you're going to be in a private room, there might be an extra fee each month for that person over and above the income that we talked about. So those are some extra considerations you want to make sure that you know about before you make these decisions. So the application process is super, super unfun. So typically it takes about 3 months to process the application, and it's only effective once Altex says it's effective. So unless you're in a nursing home, it's unlikely that there's going to be a retro pay. Lots of documents to gather. They may ask for the last 5 years worth of financial information. So my suggestion is you start gathering that now so you would have it available to you. They're going to do a financial review and an interview, and then of course that pass or medical process. And we talked about the financial power of attorney. We want to make sure somebody has the authority to sign that application. We've kind of already addressed this question on the estate recovery. On real estate, again, if there's a spouse, the house should be protected. And then there are some other exceptions that are also available. For example, as I said, a disabled child or a child under 21 or a sibling who has equity interest in the house. So there are other ways to protect the home, even if you're a single person, depending on who your relatives are and what we can do to protect it, on top of that beneficiary deed, which should survive death and therefore not be subject to the estate recovery rights, even if there's a lien on the real estate. So I'm going to move into talking about veterans benefits for a few minutes. Before I do that, Lori, I wondered if there were any other questions on Altex or estate planning that people might have before we switch to veterans benefits.
There's one question from Mary Lou who says that Mercy Care case manager told one of her patients' niece that they would not allow the supplemental premium to be paid from her funds, and the family was responsible for paying for that.
Well, it's nice to hear from you, Mary Lou. So I don't know of a rule that says you cannot continue to pay for supplemental medical coverage for the person who's on benefits. That would be a typical deduction to share of cost. I can certainly check the rules again, but typically supplemental insurance can stay in place and is a deduction to the income requirements as to what has to be provided to the facility where the person is living. If the supplemental insurance covers both the spouse who's on Altex and the well spouse, they cannot have a deduction for the supplemental coverage for the well spouse. So I'd have to probably have a few more details, and I'm more than happy to look that up. Each of the providers occasionally does have some weird rules that we have to work through in order to get to what the answer is. What's reasonable and what's acceptable. We have had some cases where it took a while, and then finally we were able basically to get a refund for a family member after we went all the way up the chain. So we can certainly look at the rules, but usually supplemental medical coverage can be a deduction to share of cost.
Yeah, I guess in this case, they would not take it from the share of cost, and they were pretty adamant about it, and the patient is a widow.
Yeah, that seems definitely odd. Usually they want the person to keep the supplemental insurance because it reduces the out-of-pocket expenses that the Medicaid program has to cover. If we have private insurance to cover whatever it's going to cover, then that's a reduction to the taxpayers. So I'm very surprised that that was problematic for the program contractor.
And then one other question that came up, if you transfer funds prior to the 5-year period to a child, that is going to count against you, correct?
So if you've made a transfer and it's more than 5 years ago, then it does not have to be disclosed under the current rules to Altex. There would be no impact on eligibility. If you make the transfer within the 5 years, you might end up with a longer than 5-year waiting period. You know, if you transferred $1 million, that might be 11 years before you're eligible for benefits. But if it was done more than 5 years before the application was submitted, it should have no impact on eligibility and does not need to be disclosed to the Altex office. All right. Well, if anybody else has questions on the estate planning or the Altex, I'm going to talk about veterans benefits, but please let Lori know if you have those questions. So we're only going to talk about the pension benefit, which is a benefit for a veteran who does not have service-connected disability. This is non-service-connected disability benefits, and it's a cash payment to help pay and offset the care expenses. It's not as thorough or rich of a benefit as All-Tex is, but it certainly is good to know about. And so it's available to the veteran themselves, the surviving spouse of a veteran, or if the spouse is the one who needs care and they're still married to a veteran, then we can typically still apply for this benefit also. Remembering that divorce is typically going to terminate the survivor's rights. So unless they're still married to somebody who would meet the requirements, they're probably no longer going to be eligible for the veteran benefit, unless they marry another veteran who meets the criteria, in which case they get to go off of that person's service record. So they have to have served active duty for at least 90 days, and at least one was during a wartime period. Anything other than a non-honorable discharge is fine. So honorable general or medical, but you can't have a dishonorable discharge and still be eligible for the benefit. Just like All-Tex, we have some income requirements, some asset requirements, and then also medical requirements. And I know that some people are not going to stay for this part, and I just want to say that I thank you so much for participating and listening to the presentation. I encourage you to stay. Again, you might find that you find somebody who is in need of the benefits, and it's nice to know that they're out there. On October 18th of 2018, the rules changed significantly, and they tried to make it more like All-Tex, so that's how they set the asset limit of that $128,640. But for this purpose, it doesn't matter if you're married or single. You can keep up to that amount of money and still probably get some help from the VA. And a house is excluded no matter where it is, and even if it's rented. So we get a little bit more flexibility in the VA program, and they're only going to look back 36 months instead of 5 years, and they have a maximum 5-year waiting period, unlike All-Tex, which has an unlimited waiting period. As I said, you could have given away $1 million, although I don't know why you would want to do that, and you might end up waiting 11 years to get All-Tex benefits. You can also get VA benefits sometimes and the All-Tex benefits at the same time, depending on if All-Tex is paying for everything. You're not going to have out-of-pocket expenses, so you might have gotten the VA benefit for some period of time, and then you lose it later. If the transfer, though, was made within 36 months of the date of application, again, that's 3 years instead of 5, then there's going to be a penalty period, and the VA penalizes the purchases of those annuities that we talked about, and pretty much penalizes the purchase of any annuity that cannot be liquidated. Also, for both programs, trusts don't work great. Typically, all of the assets have to be in the name of the couple or the person who's applying for benefits in order to be able to receive the benefit. And just like for All-Tex, if you give money back, then that transfer penalty will end. So this is generally referred to as the aid and attendant benefit. And again, we want somebody who's in need of scheduled and ongoing care. The care can be provided by a family member. They don't have to be a licensed person in order to provide the assistance. And it can still count as what they call unreimbursed medical expenses, so that some money can come into the family to cover those costs. So this is what the benefit level is, and it's the maximum that's available. So if it's a veteran with aid and assistance with a spouse, that's what the A&A stands for, the most they're going to get this year is $2,265 extra dollars. That might be enough to pay for care, but it might not. So we might still have to apply for All-Tex benefits. You're required to apply for the VA benefit if it's possible that you could get the benefit, even if it turns out you can't. But if it was possible that you could, you're required to complete the application, even when you apply for All-Tex. If you apply for the VA, you're not required to apply for All-Tex benefits, only the other way. If you're applying for All-Tex, you're required to apply for the veterans benefits. And there are some exceptions. If somebody is a single veteran and they're in a nursing home and they're on Altex, then they won't get this money. They're going to get $90 a month. And there are all kinds of rules about the interplay between Altex and the VA and what's counted as income and what is not for Altex purposes. Just like for the Altex program, it takes about 90 days for an approval, although we've seen that time frame unfortunately get longer and longer and longer. So for a while it took a year and a half, and then it got short, and then it was 90, and now it's sometimes we're not seeing approvals for at least 6 months. So it's not great to get money quickly unless the person's 90 or older or is on hospice benefits, and we can ask for an expedited claim, whether it's for the veteran or the surviving spouse of the veteran. We also need a discharge paper, but we wouldn't ever want to send the original in because we don't want it to get lost. And so it can be certified by the VA office, or you can typically provide it to one of the VA service organizations and they can help. I would be very wary of people. It's probably less of an issue now because we can't visit anybody in assisted living centers, but lots of those had folks who would come in to try and sell people annuities or other financial products and say that they would do the veterans application at no cost. Make sure you're working with an actual service organization like the Arizona Department of Veterans Services. They have free benefits counselors and they can help you through the process, because some of the application, while straightforward, is not straightforward because, for example, if you leave a section blank because it doesn't apply, they'll just assume that you missed it and the application will be rejected. So make sure that you're using somebody to help you through that process. But the whole goal of the Veterans Program is to provide additional cash for somebody who is, it has high medical expenses and not enough income to cover those expenses and low assets. So again, the rules changed in 2018. They're very different than they were before. So I encourage you to work with somebody at one of the service organizations to provide you with information so that you can get what you need on a timely basis so that you can get the person qualified. So that's the information that I have for this afternoon. I don't know if there were any other questions that came in from anybody.
Nope, no additional questions at this point. I'll give people a minute in case we have additional chat questions. Emily, I just wondered, I noticed that you were talking during COVID specifically about, you know, how people's status might change on a DNR if they did in fact want to be on a ventilator, you know, if they were becoming very ill from COVID. Do you have other advice, or are you getting a lot of other questions about Altex or estate planning? Specific to the crisis that would be helpful for other folks to know?
Yeah, I really think that the other question that's come up a lot is whether the applications at Altex are still going through, because most people are working remotely, and they absolutely are. For the most part, the folks from Altex have been working remotely for many years, so there isn't really a change in how we're doing business with those folks. So we're continuing to provide the same services just like the Altex people are doing. Those services really haven't changed. I think the question on the healthcare power of attorney has been the one we've seen the most, and the concern that people have with regard to having an admission into a facility when they are not able to see their loved one.
And how about for you? Is your office still open? Are people having visits virtually? Like what works best during this uncertain time?
So we are definitely open. Some of our staff is working remotely and some in the office. We are not doing any office visits. Everything is video or on the phone or FaceTime. And then we're doing signings in our parking lot so people don't have to get out of their vehicle. And I have a great respect for people who have to work in a mask all day because it is extremely uncomfortable. But I really do appreciate the opportunity to have spoken today. I appreciate Banner for all the work that you all do in the community and to your clients and patients that you see. And I greatly appreciate the participants for coming and listening to what is a pretty dense topic to learn about. And I certainly wish all of you the best on the journey, not only with the cognitive impairment, but obviously hope that everybody remains safe and healthy out there in the community. So thank you so much, Lori, and the team at Banner.
And thank you, Emily. That information was incredibly thorough. I know it's very complex, but you made it really presentable and easy to digest. I want to thank you so much for lending us your expertise today. I can tell just from the questions that people were really engaged. And we want to thank everybody for joining us today. You will receive via email a checkbox survey. We always do surveys because we want to continue to improve our programs and also take topic suggestions from you. In addition, our next class, you'll see in the chat box, is on Wednesday, May 6th at 10 o'clock. One of our team members from Banner Alzheimer's Institute, clinical social worker Susie Favreau, who's really an expert in this area, is going to be talking about ambiguous loss, living with uncertainty, and you can register the same way online or by calling and phoning to 230-CARE. And again, lots of great comments here. Emily, just people thanking you for great information, lots of great details, and a stellar presentation. So thank you so much for lending us your time and expertise today.
Thank you very much. I hope to see you all in person at some point soon.
I feel the same way. Thank you very much.